Well, good afternoon, everyone. It's a great delight to see so many of you here at this joint roundtable hosted by CELS, the Centre for Public Law, and the Lauterpacht Centre. My name's Catherine Barnard, and I'm going to be chairing the first part of this session. And we're obviously here to talk about the fate of the European Convention, but I suspect we're all minded of the broader geopolitical issues that are currently facing the world. Indeed, I was listening to Trump speaking at Davos as I walked over here now, and it wasn't good. I think you might have all had a look at, or at least heard parts of, the extraordinarily impressive speech given by Mark Carney yesterday. And if you haven't, I strongly commend you to do it. It's all over the web. And he is extremely blunt about the place that we find ourselves in. He notes the rise of authoritarian governments and authoritarian leadership, and a willingness to rip up what we once knew as the rules-based international legal order. And while we know this, it's rather salutary to hear from a man who's very close to it all just what a dire place we're in. However, one thing that's really striking about his speech is he says that the states who are not part of the United States and its sphere of influence need to come together with we should be principled in our commitment to fundamental values, but those fundamental values do include respect for human rights, which brings us to the subject matter of today. Now, we know the challenges externally to fundamental rights coming from all sources. We are going to be talking today about the challenges to the European Convention and the Human Rights Act coming internally, namely from the leader of the Conservative Party, Kemi Badenoch, and also from Reform, both of whom are committed to withdrawing from the European Convention should they come to power, whether it be on a joint ticket or on a ticket supporting other parties. We also know that there is a press in the UK which is strongly hostile to the European Convention on Human Rights, and not just the usual suspects. We know it's a political fight, but for us as lawyers, it's a legal fight. Now, I don't want to get too much into the politics. I think we know where we're at with that. But we also know we are not alone. There were 9 states who wrote a rather inconclusive letter asking for something like change, although quite what that change might look like was not articulated. We also know that in December, the all 46 states meeting as Council of Ministers in the Council of Europe asked for a political declaration on the reform of the ECHR. But meanwhile, we've got Lord Wolfson's report for the Conservatives, for Kemi Badenoch, arguing that we've got to leave the ECHR, and it is possible to do so without too much legal difficulty. So it's against this backdrop that the 3 centres thought it might be nice to get together and actually have a think about some of the legal issues that are involved. I don't want to spend too much time breastbeating about what a dire place human rights is in at the moment. I think we take that as read. There are 2 legal questions I would like to have a look at. First, how could the ECHR be reformed, given that there is no formal amendment procedure? And secondly, what can legally be done to reform the convention itself to discourage or prevent countries from leaving? And we've got speakers on both of those topics, but we're going to start with a short presentation from Nabil Kavipur, who's going to talk a bit about the Wolfson report and what he considers to be its strengths, its weaknesses, and some of the issues it raises. all of this to set a broader context for the discussion that follows. Bill, the floor is yours.
Thank you very much. So, also for me, very welcome. Thank you for coming. It's, I think, a very positive sign in and of itself that this afternoon is so well attended. Now, I would be very happy to speak about the report and offer my thoughts. Indeed, we had a little exchange yesterday. But perhaps before doing that, if you allow, I wanted to trace a little bit of a historical arc to help us understand how it is that the international legal order came to be. And of course, I'm speaking to a room of experts, but I want to highlight some of the perhaps key waypoints that we encountered along just a rough sort of the past 2,000 years. So not, won't keep us too long. But I think that background will, in and of itself, be very useful for us to see that although in a more formal sense, the convention is relatively young, the ideas, the spirit, and indeed also the very necessity of an international rules-based order was built on the foundation of great suffering, wars, but also signal achievements that have proven the strength of unity in diversity and ultimately the power of the oneness of humanity and European society. Talk about reform or indeed leaving the European Convention in this country is not new. In fact, just earlier we had a short exchange about the fact, and some people in the room will remember that the Center for Public Law a couple of years ago found itself in a sort of quasi-emergency state in responding to a consultation which the government had issued. At that time, the talk was to bring into being a British Bill of Rights, which although technically was not meant to override the convention, although there was a lot of unclarity of how that would act together. The very idea, of course, was quite clear, and the Center for Public Law put out a nearly 200-page statement making its views very clear that the proposed reforms would significantly weaken proposed human rights protection. However, my sense is that the current discourse around reform or indeed leaving the European Convention has a slightly different color to it. And I think there are two strands that we can detect. One strand is the strand that exercises a concern around sovereignty. So again, it has a sort of legal coloring to it. And as Catherine alluded to in her introductory remarks, I think from the political quarters, particularly, of course, reform and conservative, there is a concern that supranational treaties such as this convention, in the same manner as the European Union, of course, is a curb, an undue curb on national sovereignty, an undue limitation on what it is that a nation state is able to do, to an extent irrespective, to a degree, of the actual laws themselves. But it is the idea that a nation, a people, a government are being, quote unquote, controlled, governed, guided by an external entity, in this case, the convention as well as its court. And I think the second strand, which is a strand that you see somewhat more in the popular discourse, and perhaps in the conversations among the rank and file of society, is a conversation around identity. And this conversation has increased in volume and in intensity and also in emotionality. And casting our minds back 2 to 3 years, you did not quite detect the same level of, indeed, angst in certain quarters regarding the other. So what we are seeing in, again, certain segments is a retreat into a type of siloed, insular thinking, which is motivated in part by fear that the identity that one has and the group that one identifies with is under threat, rightly or wrongly. And what we are seeing here is, I think, we are broaching the very question of what is possible in terms of society building. Because the quiet but steady rise of nationalist thought now divides into, one might say, civic nationalism, and indeed also increasingly ethno-nationalism, which just a few years ago might have been thought unthinkable. And just to clarify the terms, a conception of civic nationalism would suggest that it is possible for people that have come from different countries, from different cultures, to come together and to create one country, or indeed to integrate into, in this case, the United Kingdom, and for that society to be cohesive and to function and to maintain an overall identity. But now increasingly we're also seeing and hearing in particular voices that suggest that that is not possible. That you cannot, in this case, be British unless you are tracing it back to the Angles, the Normans. So nobody can just come here and become British. And I mention this because you can sense that strand and that worry, but increasingly also that conviction is becoming more and more bold in again, certain segments. But I think this is partly the reason why conventions or anything that has a European quality to it is seen as an obstacle. And as I'm sure we're going to see this afternoon when we discuss some of the more particular rights and articles, that there are certain protections in the convention that counteract that ideal very specifically, such as, of course, Article 3 or Article 8, in particular in the way they have been interpreted by the Convention Court. As Catherine indicated, today we have the 2 questions which will guide our thinking. And the historical arc that I want to now draw takes its point of departure from the preamble of the Convention, which reads in relevant parts, being resolved as the governments of European countries which are like-minded and have a common heritage of political traditions, ideals, freedom, and the rule of law, to take the first steps for the collective enforcement of certain of the rights stated in the Universal Declaration. So what exactly is this common heritage? As promised, the arc is modest, just a couple thousand years. And just to reiterate, the reason that it is helpful to think about where we have come from is because it is not accidental where we have ended up. And so taking some of these waypoints in history will be very helpful for us to see the achievements that we have won collectively in Europe and indeed beyond. As is well known, I'm sure, in this room, there was nothing that resembled a modern-day human rights code during the time of Constantine. It was very much one-way traffic. There were permitted rights of action, but it was very much, of course, an imperial environment where complaints could be submitted, but it would be considered on a case-by-case basis, and there was no ex-ante guarantee that a case would be dealt with in one way or another. Interestingly, it was, in fact, religion which led to the establishment of something that began to resemble a code through the Edict of Milan, which, of course, initiated religious tolerance for Christianity. But again, it was tolerance rather than enforceable rights. It was particularly for one group, of course, and ultimately revocable, and in turn also entirely dependent on imperial will. Something that might begin to resemble predetermined standards came during the time of Charlemagne. And what we had here were the Carolingian capitularies, which effectively set empire-wide standards for good governance. And there was also an enforcement body responsible, which were known as envoys of the Lord. And they provided a type of oversight mechanism, but again, they acted as agents of the royal court, and their duties, therefore, were not to the beneficiaries of any of these principles of good governance, but of course, to the ruling power. Perhaps one of the most powerful and indeed harrowing illustrations of the absence of such some universal standard or code is the Inquisition. And of course, this stretched for hundreds of years, depending on when you begin to count. And the reason this is a very powerful example is because it lays bare, in fact, the powerlessness of the accused in this case, because once you were deemed an enemy of God, well, good luck defending yourself in circumstances where, of course, there was no presumption of innocence, no right to silence, no right to representation. And because of the inquisitorial procedure, there was no balancing, no decentralization. There was no advocacy as such, where different perspectives could be highlighted and argued. And indeed, it normalized confession and coercion as a tool of truth-finding. So, of course, today we look back on a time like this and consider literally it to be a highly backward period. But it was a defining period of European history, so it's very important to remember. And if I may, of course, today we see also in other parts of the world the oppressiveness of being labeled an enemy of God, and the difficulty that today still exists in certain parts of the world, where, although in Europe this was nearly 1,000 years ago, this plight still exists. Then, of course, after the Reformation, the religious unity began to fracture, which culminated in the 30 Years' War, which effectively was a war of various religious factions, but highly relevantly for international law, of course. The peace and the treaty that ended the 30 Years' War was, of course, the peace or the Treaty of Westphalia, which signaled a move away from, of course, the factions, the empire, and allowed nation states sovereignty for the very first time in order to regulate the affairs within their borders. However, there was also a darker side to this moon, because however empowering that national sovereignty is, it also insulates that nation from external control or standards, particularly when it comes to situations where the nation or the sovereign of that nation turns against its own people. And even though the Peace of Westphalia coincided with the florescence of the Enlightenment and the Age of Reason, that movement too was resistant to an overarching teleology. That movement too sought to reason from first principles, of course, famously exemplified by Descartes or Leibniz, or indeed also in the moral plane, Immanuel Kant. And so, perhaps the gravest example of all is then the Second World War, where the sovereignty-based model truly began to break down, because we, of course, had the situation where a country not only turned on its own people, but, of course, then began to turn on the entire continent, not to mention turning on minority groups.
Right.
And it was, of course, out of the ashes then of the Second World War that the international community realized that a pure national sovereignty model was not strong enough to guarantee security in the first place, and of course to build an order of states. Now, as is also well known, of course, the Universal Declaration of Human Rights became the inspiration for the European Convention, which was signed 2 years later. And I think it is fitting to close these introductory remarks, which I'm going to term maybe part 1 and then part 2 for the thoughts on the report, with the words of Winston Churchill. And of course, he doesn't need any introduction, but I believe also the United Kingdom was the very first signatory in terms of the temporal order of the convention. And his words, which were issued shortly before the signing in Strasbourg, also quite fittingly, were as follows: "The dangers threatening us are great, but great too is our strength. And there is no reason why we should not succeed in achieving our aims and establishing the structure of this united Europe, whose moral concepts will be able to win the respect and recognition of mankind, and whose physical strength will be such that no one will dare to hold up its peaceful journey towards the future." Thank you very much.
Thank you very much for that extraordinary arc of history in 10 minutes, which is marvellous. But it sets the context very well indeed for the next part, where we are looking at the question, how could the ECHR be reformed? Jan and Marcus, do you want to come up? So I imagine both of our excellent speakers are well known to you, but just for those, just for those of you who don't, Jan Clavers, who is our new Huel Professor of Industrial Law, we're delighted to welcome him here. I think, is this your first outing in the faculty?
No, well, outside the Lauterpacht Center, yeah.
Yeah, I mean, proper.
Ouch. I should have seen that coming. Yep.
And then Marcus Gehring, Professor of European Law and other matters.
Yes.
Yeah. Anyway, both are marvellous, and I'm going to give the floor to Jan. Thank you.
Thanks, Catherine. Thank you all for being here. This is a fascinating topic, which I approach with all the sensibilities befitting an international lawyer. And as one of my colleagues wrote a couple of decades ago, international lawyers tend to have an international project in ways that do not apply perhaps to banking lawyers or something. Like, we tend to think international law is generally preferable over its absence. So there we are. I'm also a foreigner in this country, so I have maybe a special sensibility there as well. We'll see. I guess I should not speak too much about the Wolfson report, and I won't, but having gone through it, it struck me as a bit of a lawyerly conceit, that if we get the law right, then other considerations fall by the wayside. And again, the international lawyer in me says, oh, wait a second, wasn't there 1949 genocide opinion of the International Court of Justice, which argued or asserted, I think we use the word argued too often when it should be asserted, that certain things are binding even without conventional obligation. So I'll let that hang for a moment, shall we say. It used to be perhaps that human rights were a sign of civilization. Dare I say that word these days? But apparently no more, perhaps. The international lawyer will remember that or will perhaps be able to realize that the dichotomy between, that Nabil sketched so nicely, between sovereignty and identity is maybe a bit of a red herring, in the sense, as the Permanent Court of International Justice put it in 1927, concluding treaties, participating in treaties, joining international regimes is not contrary to sovereignty, but is an emanation of sovereignty. That's maybe something to reflect upon as well. And I think indeed Churchill had something going on there. He was not only the first to sign up to the European Convention, but also the auctor intellectualis of the Council of Europe, which is the institutional home of the European Convention. So let that be said. Okay, starting point for any analysis would have to be the circumstance that there is no amendment clause in the European Convention itself, nor, as far as I've been able to ascertain, in any of its substantive protocols. So it seems to be a case of you're either in or you're out, and if you're in for eternity, or however long that takes. It usually doesn't take that long. The fact that there is no amendment clause does not mean that amendment would be impossible. It just means that there is no clause and that a different avenue has to be traveled. An alternative procedure is laid down in Article 40 of my favorite treaty, the Vienna Convention on the Law of Treaties, which does make amendment possible. It lays down a procedure clearly on the basis of the realization that drafters often forget to include an amendment clause, can't agree on an amendment clause, don't want to open up the Pandora's box that an amendment clause might entail. So there is an alternative laid down in Article 40 of the Vienna Convention. It's a bit more procedural than substantive. It doesn't say all that much other than one can launch an amendment proposal, and those who go along with it, go along with it. End of story, which doesn't take us very far, and leads perhaps inexorably to the terrain covered by Article 41 of the Vienna Convention, which is the inter se modification. Instead of, like, an amendment seems to presuppose that all current parties would join the new regime. And that's very unlikely, I guess. So Article 41 has a softer element, if you will, or a more pragmatic element, allows for a modification between some of the parties to a treaty, including the European Convention, one would imagine, inter se, but on two conditions. Such a modification maybe between the 9 states that Catherine mentioned, should not affect the existing rights or obligations of the current treaty partners. That's probably in the field of human rights not too difficult, in the sense that the human rights treaty doesn't really create rights or obligations between states, it creates rights or obligations between a state and its citizens, or those within its jurisdiction, as Article 1 of the European Convention has it. So that hurdle might not be too insurmountable. The second one would be more tricky, and that is that such a modification, for instance, between those 9 states, should not undermine or should not be incompatible with the object and purpose of the convention concerned. Now, object and purpose is a slippery notion. It can mean, as Humpty Dumpty would say, it can mean whatever we want it to mean, but in the context of a human rights treaty, it's pretty decent assumption to think it should, a modification of a human rights treaty should not diminish human rights protection. That seems to be what the Wolfson report is aiming for. So, if a formal amendment involving 46 states, 45 maybe these days, is not within reach, and a modification inter se between some might be difficult to achieve, then what are the alternatives? One might be, I drew up a bit of a list of bullet points. I am digitally incompetent, so I don't have nice slides with bullet points, so I'll just mention them while we go along. The first alternative could be to adopt an interpretative declaration by all parties together, saying effectively that the right to life shall not mean the right to life, or something like that. Some might resist, though, if only out of spite, and hopefully some would resist also for more substantive reasons. So that's one thing. One possibility, but unlikely, because not really tolerated by the general law of treaties, would be to introduce a reservation at this moment in time. One usually does that ultimately at the moment of ratifying, rather than a couple of decades or even 70-odd years into the life of a treaty. So it should be impossible, and I'm fairly certain a reservation submitted now, or a set of reservations, would be shot down by the European Court of Human Rights. And the European Court, over the years, has appropriated the power to be the final arbiter of the legality, the acceptability of reservations to the European Convention. That's fairly special. There are few, if any, courts in the world that would have that kind of power appropriated. The Human Rights Committee under the UN, ICCPR, the Civil and Political Rights Covenant, tried, but that was shut down by some powerful parties, including this one, the United Kingdom, on the theory that since the Human Rights Committee cannot take binding decisions, it can also not take binding decisions on the acceptability of reservations. But the European Court of Human Rights has carved out a special niche for itself. So that's also not a very likely avenue. Another possibility might be to introduce a unilateral interpretative declaration. The United Kingdom sending a letter to Strasbourg saying, we hereby understand Article 2 to mean this and this, but not this and this. Article 3 to mean this and this, but not this and this. Can always be done, but success is not guaranteed, partly for the same reason. Final arbiter on legality, acceptability, applicability of such interpretative declarations made unilaterally is again the European Court of Human Rights. So one enters the same one-way street, one might say. Then, more dramatic gestures why not withdraw altogether from the European Convention? That is, under the general law of treaties, not to be recommended. There's a very strange provision, in a way, Article 56 of the Vienna Convention, which suggests that if there is no withdrawal clause, then withdrawal is not allowed unless the parties agree or unless it follows from the nature. Imagine the scare quotes. The nature of the treaty that such withdrawal should be allowed. If you go back to the drafting of the Vienna Convention, what states had in mind was in particular military alliances that, if push comes to shove, you want to get out and there is no withdrawal clause, then fine, then you go because it's the nature of the alliance. But with other treaties, that has not really been put to the test very often. And it is perhaps in that light not surprising that Brexit was unthinkable until the Lisbon amendments of the EU treaty, when the withdrawal clause was first introduced. And international lawyers have bad memories of withdrawal clauses. Think of Article 1 of the Covenant of the League of Nations. It's amazing. The very first opening article of the Covenant said, we hereby establish a League of Nations, and if you don't like it, you can withdraw. Getting married with the divorce papers already. Not perhaps the best possible idea at the time. Anyway, the point is moot because Article 58 of the European Convention does allow for withdrawal after 5 years of having been a party. Well, that is royally met by the United Kingdom. One can withdraw, but that should not affect outstanding obligations. That's a perfectly reasonable provision, I guess. But withdrawal it comes with a few drawbacks, right? It is not a good look. The optics for a country that can boast a Magna Carta. Some of my human rights friends would say human rights started in 1215 here. Not sure I agree with that, but it does give a certain flavor, right? Not a good look, plus the substantive rights are to a large extent covered also by the Human Rights Act, so you would have to tamper with that, unless you'd only go after the the European Court of Human Rights and say we want to get rid of the court, but not of substantive rights. But that's not the impression I got from the Wolfson report. Plus, the rights are laid down also in a bunch of surrounding treaties. Think of the Refugee Convention. Think of the Covenant on Civil and Political Rights that I mentioned before. So if you want to get rid of the whole thing altogether, you have to step out of the whole thing altogether. Now, the ICCPR and the Refugee Convention do not have their own courts, but how relevant is that really? John Austin, I guess, would have said that's perfectly relevant 200 years ago because international law needs to be, is only law if it is commands backed up, but debatable. Now, more interesting then is the possibility of a withdrawal followed by readmission, but with reservations. That actually has happened a few times. Classic example concerns Bolivia and the 1961 Convention on Narcotic Drugs. Bolivia left it in 2011 because Bolivia had the traditional practice of chewing cocoa leaves, which was considered incompatible with the Convention on Drugs. So it left in 2011, rejoined in 2013 with a reservation reserving for Bolivia the right to keep the practice of chewing coca leaves intact. Sweden did something similar in 2002 with a convention on multiple nationality. Whereas Bolivia waited 2 years, rather politely, Sweden rejoined the next day with a reservation. This gives you a little bit of a flavor of what they may have had in mind when withdrawing immediately. And Guyana did something like that concerning the death penalty that is not really appreciated under the Civil and Political Rights Covenant. And Guyana also immediately, maybe not a day later, but a short period later, rejoined the ICCPR with a reservation, reserving the right to keep the death penalty in place. Now, the problem with all this is, of course, again, that the legality of reservations is in the hands of the European Court of Human Rights. So it might not be terribly effective to do that. Sorry. A further possibility, and that has proved successful every now and then, is to shout loudly, clearly. That sounds kindergarten. Well, a lot of international law is on the level of kindergarten, I tend to think. Yeah, sad but not untrue, perhaps. No, in 1975, the European Court came up with the Golder judgment, heavily criticized at the time in a dissent by Sir Gerald Fitzmaurice. This was the court going wild, running wild. It read into the right to a fair trial, Article 6, also the possibility to start civil proceedings. That, Fitzmaurice said, that's a bit too much to read into the right to a fair trial, because that presupposes a trial, right? Not that you can start civil proceedings, he said. So there was a bit of noise after the Golder judgment, and a year later, lo and behold, Andyside came out, where the court came up with its well-known margin of appreciation doctrine, which suggests that if you loudly voice dissent with a judicial approach, the judges might even hear you, even if they are tucked away in Strasbourg, and start to think, ooh, that's probably not very desirable to keep that kind of noise going. Why don't we invent something to soften it? Because that's what the margin of appreciation does, right? It tells states that in a number of circumstances, they are better placed than the court itself to make a particular judgment, and in particular on questions of morality, I guess. At least in Andyside, that was the case. Or then, you could do what Russia did 4 years ago. You can invade a neighboring country, get expelled from the Council of Europe, which then also means that your membership, your party status to the convention comes to an end. Not the most elegant, not the most practical, not the most cost-efficient way of doing it, but in terms of effectiveness, no one complains about Russia anymore not respecting the European Convention, right? It's a station that we have passed some time ago. This is Article 58, paragraph 3, by the way, that if you get expelled from the Council of Europe, you also lose status under the European Convention. Now, substantively, this seems to be about three main things in the Convention. If I read the Wolfson report correctly, there's the right to life. There's the right, that's Article 2, the right to be free from torture, inhuman and degrading treatment in Article 3, and then family life, Article 8. The first two of those are considered non-derogative, so one should not really tamper with them. Then there's mention in the Wolfson report of what they call a wonderful Orwellian euphemism, I think, the veterans problem. I don't really grasp why veterans suffer so much if the UK is engaged in a military operation abroad and should respect human rights. It seems to me that the idea there is to operate militarily without too much scrutiny abroad, like in the good old days. So here at stake is Article 1, the very notion of jurisdiction. Who is under the jurisdiction of the state when it is a party to the European Convention? And then there is what is called, again, a little bit Orwellian, the prosperity problem. Is basically how can we fight climate change? How can we limit attempts to limit climate change. And that again involves the right to life, as Klima Seniorinen made clear. Was it last year, 2 years ago? Marcus would know far more about that than I do. So, to round up, none of those avenues seem to be very promising, very effective. And that raises the possibility of just plodding along. The cynic in me would say, why even discuss? There is a cynic in me. It's the international lawyer sensibility. But of course, zwei Seelen in einer Brust, there's also a cynic there. Why withdraw? Why not just do what Turkey does, what Russia has long been doing? You stay a party, you trample upon human rights left, right, and center. But so what? It's still, you can still say you're a party and do pretty much as you please. I should maybe also add that that's pretty good company to keep, right? Russia, Turkey. Thank you.
Yeah, I should caveat my intervention to highlight that I've always, in my career, tried to stay away from really difficult questions of war and peace and human rights violation and international crimes. But in this increasingly interconnected world, I think we all need to start upgrading our knowledge on general international law and maybe EU law in the process as well. The question we have for this part is how could the ECHR be reformed given that there's no formal amendment procedure? And Jan already sketched out the most important parts. Of course, all parties could come together, all 46 Council of Europe member states, and could just adopt a new European Convention, and that is not completely unprecedented, right? The European Social Charter, not very well known in this country, I might say, has been amended and reissued, so to speak. So there is some precedent in the Council of Europe to maybe be doing that. We misunderstand the European Convention if we discount the protocols. In a way, the way the members of the Council of Europe amend the convention is via the protocols, right? And we can see substantive rights being added in protocols 1, 4, 6, 7, 12, and 13. We can also see procedural reform and institutional reform in protocols 11, 14, 15, 16. So why do we need to sort of mount, like the Wolfson report does, an existential crisis when there is a mechanism readily available by adopting new protocols? Now, in the field that I know best, adopting new protocols is in itself not an easy task, right? For the last roughly 20 years, since 2007, we've been debating first in the Parliamentary Assembly, but then also in the Council of Ministers, the addition of a protocol on the right to a clean, healthy, and sustainable environment. And needless to say, that protocol has not yet seen the day of light, which is somewhat surprising because out of the 46 Council of Europe members, 42 voted in the General Assembly and before that in the Human Rights Council to recognize the right to a clean, healthy, and sustainable environment in the UN context. So you could ask, why are we still struggling to add such a right when it comes to an additional protocol? So I'm just mentioning this because, it illustrates that even the protocol route is not the most straightforward, even though many of the Council of Europe countries actually have such a right already established in their in either their constitutions or in domestic law. So the Wolfson report doesn't even mention the protocol avenue, right? It has this bizarre, as Jan highlighted, the sort of Sweden option, right? Or it recommends to withdraw and then rejoin with a reservation. And there are, of course, certain limits to that. But why not make the major effort to maybe get a protocol adopted that does what maybe the government of the day wants? So if you read paragraphs 297 following of the Wolfson report, it completely ignores the protocols to the European Convention. There's also, you know, in a way, if the main interpreter of the convention is the court, and member states largely control who serves on the court, isn't it really up to the member state to select judges for the European Court that might develop the jurisprudence, the case law, in a way that they find palatable? The UK judge has been very well informed and very nuanced in his opinions. But there is perhaps something on a procedural level that the Strasbourg court could change, right? Why is it that the member state judge is always sort of in charge of cases for their own member state, right? Shouldn't it be a much more diverse set of opinions which, you know, might not respect the local sensitivities, but maybe give a broader view of human rights interpretations from across the continent? There is, of course, the way to reform the convention through institutional procedure or procedural practice. Maybe we can sort of come back to this point. Protocol 15 does a little bit of that, and some commentators say Protocol 15 has been utterly unsuccessful. I would disagree with that. I think it has changed the way the Strasbourg court operates, and while not completely fulfilling maybe what some of the drafting nations wanted, it has had good success. Now, we did the fourth way is perhaps political declarations. Jan called it shouting, right? If you read, for example, some of the ministerial declarations, such as the Brighton Declaration, it can only be interpreted as shouting. But it's, according to some commentators, has been not very successful. Like, normal international treaties can be influenced by joint interpretative declarations, right? So in the trade field, we have many examples. Dare I say, the famous Windsor Agreement by the previous government with the EU is in many ways not more than an joint interpretative declaration. But the Court of Justice, the European Convention in Strasbourg, doesn't have that as an avenue. Also because it declares the court the sole interpreter of the convention. And that is maybe something that member states could look at. The final point that is also completely neglected, in my view, in the Wolfson report is how national constitutional orders interact with the European Convention. And while Jan mentioned two of the outliers, right? You can be a party to the convention but completely ignore any of its effects or instruct your judiciary not to follow it. There are many more nuanced forms. I think the UK with the Human Rights Act and the automatic adoption, not just of the convention, but also the court judgments, is also a bit of an outlier if you look across the Council of Europe countries. The country I know best, Germany, the German Constitutional Court in the Görger-Gülük case in 2010 adopted perhaps a much more pragmatic approach, right? The court had to express itself in a family law case what to do with a judgment of the Strasbourg court. And the Constitutional Court ruled or declared the following. The European Court of Human Rights establishes that there has been a violation of the Convention, and if this is a continuing violation, the decision of the Strasbourg Court must be taken into account in the domestic sphere. That is, the responsible authorities or courts must discernibly consider the decision and, if necessary, justify understandably why they nevertheless do not follow the international law interpretation of the law, right? So this language must be taken into account is maybe a bit difficult to understand, but many Council of Europe countries have sort of safety valves around the decisions of the Strasbourg Court, right? If they're good public policy reasons, well, maybe, still taking into account the spirit of the decision while not following exactly the instruction of the Strasbourg Court might be a lesser evil than completely withdrawing from the convention. That, I think, is everything I wanted to say. We're in this university that is 4 years older than Magna Carta, so maybe we are not bound by fundamental rights in the same way. But I think, in my view, Jan was very polite, sort of calling the Wolfson Report a work of smoke and mirrors. I think it's, quite frankly, in my view, it omits the most obvious answers and tries to give an opinion for a purpose, and so should not be treated as an objective legal opinion, but rather written for a client. Thank you very much.
Well, welcome back, everyone. It's my great pleasure to chair this next panel on what can legally be done to reform the convention system to discourage or prevent countries from leaving. We'll be focusing on two issues, immigration and climate change, and we have two terrific speakers to guide us through those topics, both of whom are experts on public law, ECHR, and international law. We'll hear first from Darren Peterson, who will focus on immigration, and then Stevie Martin, who will focus on climate change. Unfortunately, Kirsty is unable to be with us. So, Darren, I'll hand over to you.
Or I'm going to click record.
Yes, it's all done. Oh, it is. But do you want to check, actually?
Great. Well, thank you very much. And perhaps just to caveat my remarks, as Sandy suggested, I was meant to be part of a duet for the issue of immigration, but today I'm singing solo because Kirsty Hughes is unfortunately unwell. So my section won't be as perhaps broad or dealing with all of the issues that perhaps would have been envisaged on this because it was going to be two submissions. But I'll begin by first discussing the need to try and reform the narrative surrounding the ECHR. I'll then consider the recent move by a small majority of convention states to reinterpret the convention in the context of immigration, which we've heard about very briefly before. And then I'll conclude by seeking to contextualize the obligations under the ECHR with respect to migration within states' broader obligations within international law, and I'll explain why that's important in the end. So perhaps in Kirsty's absence, I thought it might be useful to begin this discussion with the same issue that she began a recent blog post that she published with the UK Constitutional Law Association on the topic of migration and the reform of Article 8. Kirsty began by arguing that it is imperative that the debate to reforming the ECHR in the context of migration is premised on a clear understanding of the legal issues and grounded in reality, not misinformation. And as she persuasively argued, quoting Alan Green, we need to bring facts to a vibes fight. Yet that task is incredibly difficult, and for a number of reasons. So first, the Home Office does not regularly publish statistics on the extent to which deportations are prevented on the basis of the European Convention on Human Rights. According to the Bonavero Institute, of the statistics we do have, which were last published in June 2021, the number of foreign national offenders who successfully appealed against deportation on human rights grounds alone is very small. According to their analysis of the available data, and again, it's old data now, of the foreign national offenders who were deported from the UK each year, just 3.5% successfully resisted their deportation on human rights grounds. And for those who base their appeal solely on the grounds of Article 8, so on private and family life, this number was just 2.5%. But despite these small numbers, when the Bonavero Institute tracked UK news reports mentioning the European Convention on Human Rights from January to June 2025, they found that 75% of these reports focused on immigration, and in particular on human rights-based appeals against deportation of foreign national offenders. Perhaps the single best reform we could implement to prevent the UK from leaving the ECHR, or at least to try and make it a little bit harder, is to require the Home Office to regularly publish statistics that demonstrate the extent to which the ECHR and the HRA is being successfully used in deportation cases. It is only with this information that it will be possible to demonstrate the reality that the European Convention on Human Rights does not pose a significant barrier to the implementation of the government's immigration regime, and that the vast majority of deportations do not appear to be resisted on human rights grounds. The same is true for the role of the European Court of Human Rights. In the past 45 years, so since 1980, there have been just 13 cases in which the court has found that a deportation or extradition from the UK would violate the convention. And just 4 of these cases concern the right to private and family life. In the 16 other deportation cases, so the majority, that involved the UK during that time, the court found no violation of the convention. Statistics regarding deportation and extradition cases across the entire jurisprudence of the European Court of Human Rights requires significant effort to compile. I don't know if anyone's tried to use HUDOC for such a thing, but it's incredibly difficult. And the court could itself play a greater role in demonstrating that migration is a small part of its overall jurisprudence, and that, at the very least for the UK, the majority of cases have been concluded in the state's favour. It should be said that that in the context of granting leave to remain and family reunification, there are some statistics to the contrary of what I've just said. So in the recent white paper presented by the Labour government in regards to reforming the immigration regime, they do suggest that a high number of arrivals into the UK from people who would not otherwise have the right to live here are being accepted on the grounds of private and family life. So over half of family and private life applications made from within the UK are granted leave on the basis that refusing them would breach Article 8. Despite this, though, as outlined above, these cases garner far less attention and concern. These are not foreign national offenders or asylum seekers per se, and the majority of media reporting and discussion is focused on foreign national offenders and incorrectly or misleadingly overstating the role that the ECHR plays in enabling such individuals to resist deportation. I acknowledge that perhaps this is an obvious and not particularly groundbreaking idea for reform, but it appears that it's an important starting point in addressing this issue. And an important starting point is not to focus on the ECHR itself, but on trying to reform the narratives surrounding it, because as with much of the Wolfson report, it appears misleading or misstated. Work clearly must be done to dispel the apparent myth that the ECHR poses a significant barrier to the implementation of states' immigration regimes. And while these considerations may be beyond the scope of law or lawyers, reforms could be made to ensure that the appropriate data is made publicly available, and scholars, NGOs and civil society could then work on ensuring that the relevant statistics and information from the court's jurisprudence is compiled, made available, and able to be analysed and communicated. Although it must be noted that it's clearly difficult in the present moment on any issue, let alone as one as politically charged as immigration for Trump vibes. Sorry, Trump is in my head now. So the next issue I wanted to turn, and so moving on from discussing reforming the narrative surrounding the law to discussions of reforming the law itself, perhaps after the previous remarks should be titled States Yelling at the Court or Yelling Loudly at the Court. So I'm sure many people here are familiar with the numerous proposals that have been made largely at the domestic level for reforming the interpretation and the application of the European Convention on Human Rights in the context of migration. I've just mentioned the recent white paper of the current government. There was also the consultation by the previous government that led to the drafting of the Bill of Rights. And as Nabil said, there was a bit of a crisis meeting of the Centre for Public Law in terms of responding to that. There was also the Illegal Migration Act, the Safety of Rwanda and Asylum Act, but perhaps to discuss broader reforms at the convention level on this issue and possible mechanisms for achieving this, I thought I'd begin this section by discussing the very recent and therefore still quite nascent moves by a small majority of Council of Europe states, which suggests that they may seek to pursue the reinterpretation of the convention in the context of migration as a means of achieving their policy goals in this area. So, as has been briefly referred to previously, in early December last year, 27 convention states, including the United Kingdom, published a joint statement highlighting the challenges that they face in the context of migration and their concern that a failure by them to respond to these challenges would undermine the protection of fundamental rights and erode confidence in the convention system itself. In a joint statement that was released at the same time as that statement by the Danish and UK Prime Ministers, they framed this challenge far more existentially. So they stated that unless governments were able to reflect their citizens' concerns on migration, the populace in Europe would win. So briefly, as I recognize not everyone may have had the chance to read this statement, it outlines 5 key challenges that the Convention must meet with respect to migration, including that Article 8 must be rebalanced to ensure that migrants convicted of serious crimes can be expelled, that there's a lack of clarity regarding the scope of Article 3 in the context of extradition and expulsion, that states must not be prevented by the Convention from entering into agreements with third countries, that states must be able to apply clear rules and processes with respect to migration, and that it must be recognised that human rights are being abused by hostile regimes and individuals with ulterior motives. I'll move on from that. It's not to say that I agree with all of them and certainly do not, but the statement then notes that certain key interpretive principles with respect to the Convention will be important for addressing these challenges. So it points to the principles, including the right of states to control their borders, the principle of subsidiarity, proportionality, and shared responsibility, as well as the de minimis principle and the principle that human rights must be balanced against national security and public safety. These are, of course, principles that the court already employs to interpret the Convention in the context of immigration, but the implication of the statement is that the 27 states will seek to utilise these principles to narrow and further restrict the interpretation and application of the European Convention on Human Rights, particularly Articles 3 and 8, in the context of extradition and deportation. It's quite difficult to discern from this statement the process or mechanism by which the 27 signatories envisage the reinterpretation of the Convention to take place. If it's envisaged that the European Court of Human Rights will simply acquiesce to much narrower interpretations of Article 3 and 8 in the context of migration, this will be a slow, as has been mentioned before, a slow and unpredictable process that could not be guaranteed to achieve the outcomes desired by states. In any event, it must be said that on this issue, the court is clearly already willing to engage in dialogue with domestic courts and legal regimes with respect to the proper interpretation and application of convention rights in the context of extradition and deportation. We've seen this most recently with respect to the dialogue between UK courts and the European Court of Human Rights on the application of Article 3 to extradition cases, where an individual faces a real risk that an irreducible whole life sentence will be imposed upon them. As many people here will be familiar, and as Kirsty, Stevie, and Stephanie's new book highlights, since the House of Lords decision in R. Wellington, there's been a significant dialogue between UK courts and the European Court of Human Rights in respect of Article 3 in extradition cases. This ultimately culminated in the decision of Sanchez in the UK, in which the court affirmed the absolute prohibition on Article 3, while noting that the Winters criteria, namely that a whole life sentence must be de jure and de facto reducible to be compatible with Article 3, applies in an adapted way in the context of extradition. Scholars rightly criticise this approach as contradictory, but it does signal the possible receptiveness of the court to some of the concerns raised by states in their joint statement and on the reinterpretation of the convention itself. Indeed, in the context of Article 8 and migration, it's been argued by scholars that the court has shown extreme deference to states. The UK's own legislative interventions with respect to foreign national offenders requires deportation with very few exceptions, an approach which has survived the scrutiny of both domestic courts and the European Court of Human Rights, and which has been shown to be convention compliant. Arguably, the court has reserved only a small core of fundamental obligations on the state in this area, including judicial oversight and supervision of immigration regimes, the requirement to take account of the court's case law, and the fundamental prohibition on inhuman and degrading treatment, among some others. And it's these fundamental core of things the court has reserved that the Wolfson report is criticising. It's difficult to see how much further states can go without encroaching on these fundamental principles and without requiring the court to reverse its approach and perhaps overrule prior precedent. Although it's not clear if this is the intention of the 27 signatory states, and the joint statement suggests more work will be done to progress this issue at the foreign ministers meeting on the 15th of May this year, hopefully we'll have some further clarity by then and be able to assess the appropriateness and legality of any proposed measures. Just to conclude on this point briefly, and to perhaps raise some more questions rather than answers, if instead the proposed approach of states is to create their own coordinated interpretation of Articles 3 and 8 of the Convention with respect to immigration, this raises some intriguing and difficult questions for us and for the court. If a majority of high contracting parties coordinate an interpretation of Articles 3 and 8 of the Convention within their own domestic legal regimes that's far more restrictive than what the court has already imposed, how is the court to deal with this? So while the court, as we've said, is the sole arbiter and responsible for the interpretation of the Convention, it does so on the basis of the principle of subsidiarity, the living instrument doctrine, and the evaluation of a European consensus. If a majority of states reject or challenge its interpretation of the Convention in a given context, how is the court to proceed? This is not a question for which I have answers, but perhaps it's something that can be raised and discussed during the discussion. So on the final point, and I will conclude shortly, the final point I wish to make is not a proposed reform to the Convention itself, but rather a reform to the court's approach in situating its reasoning within the broader international legal regime for the protection of migrant rights. This would operate as a means of demonstrating that the court's decisions accord with states' broader international legal obligations with respect to migration and challenge the view that it goes beyond what is agreed or accepted, or what has been agreed or accepted by states. In many respects, the court has a robust approach to incorporating broader principles of international law into its decision-making where they are relevant to determining an issue before it. So, for example, in the recent decision of Ukraine and the Netherlands and Russia, the court continued its approach of extensively examining its relationship between the principles of international humanitarian law and the rights protected by the Convention in cases concerning armed conflict. For almost every violation alleged by Ukraine and the Netherlands, the court examined the relevant and applicable rules of international humanitarian law to determine if it restricted the scope of the Convention right or meant that a violation could not be found. Similarly, the Palermo Protocol and the Council of Europe Convention on Action Against Trafficking in Human Beings, the ECHR, features prominently in the court's jurisprudence regarding Article 4 of the Convention. In almost every case concerning human trafficking, the court will examine the relevant provisions of ECHR when assessing states' obligations. Similarly, it's not uncommon for the court to consider Articles 31 and 32 of the Vienna Convention on the Law of Treaties when interpreting other international treaties, nor to acknowledge its role as an international court interpreting and applying international law. However, this does not appear to be a particularly common approach in immigration cases. So, for example, in the 2016 decision of Pashposhvili and Belgium, the court held that deportation of a foreign national offender in circumstances where they'll be unable to receive appropriate treatment for their leukemia and recurrent tuberculosis violated Article 3 of the European Convention on Human Rights, as it would have exposed the applicant to a serious, rapid, and irreversible decline in their state of health, resulting in intense suffering or a significant reduction in their life expectancy. In this case, the court made no mention of other relevant international legal instruments or states' international legal obligations within their decision. However, in that case, the court arguably imposed a higher standard for applicants to meet, so an easier standard for states, in order to resist deportation than the standard imposed by the Human Rights Committee under Article 7 of the International Covenant on Civil and Political Rights. So, for example, in the 2002, so almost 15 years prior, communication of C in Australia, the Human Rights Committee held that Australia had violated the ICCPR in circumstances where the harshness and length of its detention of the applicant, a refugee from Iran, resulted in a significant deterioration in his mental health, causing him extreme depression, paranoia, tremors, and suicidal ideation. On the applicant's release from immigration detention, he broke into a friend's homes with knives while suffering from delusions, leading to a non-custodial sentence and a deportation order from the relevant minister. The Human Rights Committee held that the deportation of the applicant to a country where it was unlikely that he would receive treatment necessary for the illness Australia had caused would violate Article 7 of the Covenant, which is the equivalent of Article 3 of the ECHR. Decisions of the European Court of Human Rights are not made in isolation. They're part of a broader international human rights regimes and are often consistent and reflective of the state's broader international legal obligations. For example, in 2012, the ECHR held in Hirsi Gemma and others in Italy that Italy's interception of 200 migrants at sea and their return to Libya without consideration of their treatment there violated Article 3 of the ECHR, in addition to Article 4 of Protocol Number 4, among other provisions of the Convention. This decision can be situated within a broader international legal context in which other international bodies have also examined Italy's approach to pushbacks and their protection of migrants at sea and found violations of fundamental principles of international law. So, for example, in 2021, the decision of AS and others in Italy, the Human Rights Committee found that Italy's failure to respond to a distress call and come to the rescue of 200 migrants who ultimately died in a shipwreck in October 2013 violated the migrants' right to life under Article 6 of the ICCPR. In that communication, the Human Rights Committee also examined states' broader obligations under the Law of the Sea Convention and their duty to render assistance to ensure protection of life at sea. The European Court of Human Rights and the European Convention do not act in isolation, as I said before, and states' immigration regimes are subject to broader obligations within international law, another point that the Wilson report tries to downplay. What these examples and comparisons seek to suggest is that perhaps if the European Court of Human Rights were to utilise or at least refer to states' broader international human rights obligations within its reasoning in immigration cases, it may be able to dispel the notion that the obligations that it's imposing on states are too onerous or that they go far beyond the scope of the Convention. And to some extent, we're already seeing this approach be implemented, with the UK Supreme Court stating in its recent AAA decision, and I quote, "The principle of non-refoulement is given effect not only by the ECHR, but also by other international conventions to which the UK is a party. It is a core principle of international law to which the UK government has repeatedly committed itself on the international stage, consistent with the country's reputation for developing and upholding the rule of law." This reasoning quite forcefully situates the non-refoulement principle as a fundamental principle of international law that has been consistently supported by the United Kingdom, and that it's not an obligation that has been imposed by so-called unelected judges in order to stifle states' immigration regimes. Such an approach may be even more important as courts are increasingly called upon to examine the legality of offshore or third state processing or detention regimes. In addition to the AAA case and the Rwanda policy, the Italian Constitutional Court has recently raised questions around the legality of Italy's Albania scheme, and the EU Pact on Migration and Asylum will soon result in the creation of return hubs in third countries, which may ultimately be examined by the European Court of Human Rights or by the European Court of Justice. In this context, it's worth noting that just last week, on the 14th of January, the UN Committee Against Torture found that Australia, the state which the Wolfson Report holds as a model for the UK to follow, had violated the Convention Against Torture in its treatment of the applicant during his detention in an offshore detention facility in Papua New Guinea. The committee found that the applicant had been kept in inhuman and degrading conditions, including in circumstances where the applicant had his throat slit by an unknown assailant while in detention, who had never been identified or brought to justice. The committee found that although the detention occurred in Papua New Guinea, Australia retained jurisdiction under the UNCAT as they funded and built the detention facility and ultimately controlled whether or not the applicant was detained. Again, this is just to highlight that the European Court of Human Rights or domestic courts applying the relevant legal regime are not acting in isolation, that they are part of and acting consistently with a broader international human rights regime, and that there is in fact a core minimum of fundamental rights that apply to migrants. The convention system appears to be under existential threat because some states hold the view that the obligations that are being imposed upon them by the European Court of Human Rights go beyond what they accepted or agreed to when they acceded to the convention. However, as the above suggests, an examination of states' broader obligations within international human rights law and the relevant international legal instruments that apply to migrants demonstrates that this view does not stand up to scrutiny. Perhaps if the European Court of Human Rights was more conscious of this in their reasoning and demonstrated that the obligations on the ECHR are largely consistent with states' international legal obligations, it might discourage states from leaving the convention system, as it provides a place for coordination and dialogue on these fundamental issues. Ultimately, irregular or illegal migration and immigration more broadly presents a collective action problem for states and requires coordination in order to be resolved. No state can resolve this issue or meet these challenges on their own, so international law and the core fundamental rights that it protects will always need to be at the centre of these considerations. Reminding states of this fact may be a useful step to ensure the convention system holds together. Great.
Thanks very much, Darren. Now over to Stevie.
A very hard act to follow, riddled as I am with flu, so I sound even more Queensland than I normally do, so I'd like to apologise for that. Yes, thank you so much. See, antipathy and hospitality. Thank you at its finest. It's always weird as an Australian to have conversations about rights erosion and rights protection, because as a nation we aren't terribly well known for our rights protections. And yet, again, as a Queenslander, it's an odd cognitive dissonance I find myself in these days when my home state is doing things a little bit more progressively and a little bit more forcefully than the UK. I was originally going to speak about veterans and was going to have Stephanie speak with me, but she has welcomed the addition of her delightful granddaughter. And so we have decided that I will speak to climate change. And it seems odd in some respects to stand here and say that climate change poses an existential threat to the court, because it poses an existential threat to all of us. And I think probably the court is of the view that, well, to the extent that you're worried about our jurisprudence, we're worried about temperatures rising and ocean levels increasing. And so, you know, if in 20 years' time we still have a court that looks like this, then maybe we can discuss the merits or demerits of VARAM. But still, we're here, and it is important, not least because it is almost tacked on as an addendum in the Wolfson report. So, you know, you see it in the context of prosperity, this pernickety, this pesky ability to challenge planning decisions and policies on the basis of climate change. Is there a way, the Wolfson report says, is there a way, it asks, can we, in some ways, alter this approach of applications being founded in human rights? And one might say, I think the horse has bolted there, because cases like Finch probably indicate to you that it's not human rights that you need to be concerned with. It's unlikely that we're going to be going to the Human Rights Act to challenge decision-making with respect to climate change issues in this jurisdiction. Indeed, we haven't been. We've been looking to tort. Lord Sales last year gave a speech in which he very strongly indicated that tort might find its resurgence, if you will, because, you know, in a very glib way, we find ourselves in a situation where causation is no longer the speculative nature it once was with respect to climate change. We are living it. The realities of climate change are currently before us. And so it's no longer a matter of if, but how bad, realistically. So those causes of action that we traditionally have perhaps avoided, and Australia is still doing it. We had a decision recently by the federal court that has declined to find a novel duty of care on the basis of you know, traditional principles of tort law. It's not to suggest that we are there with respect to private law, but it's certainly making its presence known, and planning and traditional statutory interpretation, which Finch was, is where we're going to see, I think, the challenge. But as I say, climate change, the court's judgment, the Grand Chamber's decision in Varan, it does contribute to this wider narrative. And I think, you know, this idea that we need to reform the narrative is so central to the longevity of the European Court and the Convention, because so much of it is a misunderstanding. So much of it is a lack of and that's not a criticism. You know, I say to my students, it's a privilege to learn the language of law. Right? It is a privilege to know how to find judgments first and foremost. It's a privilege then to know how to break down a judgment, to understand what the meaty bits are, what the ratio is, what the dissent is, what it means. Of course, for the majority of people, they aren't going to do that. They're not going to go to HUDOC, as you mentioned. Lawyers go to HUDOC and we think, what are we doing here? Why have you updated this? And now we can't find things that we used to be able to find. So to expect the average person to go to the court's website, even though it has made a massive effort to try and be more accessible with its fact sheets, I think is a nonsense. So we do have to shift this narrative. And I think that actually is, in terms of securing the court's longevity, is the primary focus. But the court is doing things. It is doing things in its jurisprudence, right? So I would, I again, as I say, it feels weird to stand here because I think most of us in this room would accept that climate change is a reality. We, 3 or 4 years ago, we may have had a bit of healthy debate about the extent of it. That, I think, is well gone. We know it. We know it. Again, as an Australian, I know it in respect of island nations. We know it, more generally as lawyers, international lawyers. We appreciate the advisory opinion from the ICJ. We appreciate the advisory opinion from the Inter-American Court, the advisory opinion from the Court of the Seas. There have been a multitude of decisions. The IPCC has made it clear where we stand with respect to the catastrophic effects of climate change. So it does feel a bit bizarre to stand here and say, well, how can this issue, this one, be something that is posing a legitimacy crisis for the court? And it's not so much the substance of the issue, but it's the way that the court has had to fandangle it in order to get around the fact that the convention is very fixed, right? Standing is very clear. Article 34 of the European Convention is pretty clear in terms of how we have standing. And you have to be a victim, and victim status is very narrowly defined. And the court has sought to provide opportunities. So for where somebody has died, for instance, there are ways in which we can try and render it effective. Judge Sergedes, the leading proponent of effectiveness, will find many a way for us to get there. But few people would deny that Varen wasn't crafty in its approach to standing, right? And those that work in climate change accept it as it needed to happen. Yep, we may not like the fact that it had to be worked that way, but we got there. It had to happen. And I think it's telling that the Wolfson report actually acknowledges, oh, look, the HRA and the European Convention, that's not really our primary focus with respect to climate issues. It is the planning, it's the environmental impact assessments, it's, the Climate Change Act. That's our concern, not the Human Rights Act. We probably still need to repeal it. There's that off-the-cuff reference to we should probably still get rid of it, but that's not what's going to solve these obstacles. And again, the response to the Grand Chamber's decision last year hasn't been a huge amount of criticism of finding that Article 8 requires states to take these steps. Because, as Darren noted, the European Court doesn't exist in a bubble. It would have been anomalous almost if they had have turned around and said, no, the right to private life, this incredibly broad right that we have interpreted incredibly expansively, does not actually confer on states an obligation to take steps to effectively mitigate against real risks to the private and family lives of individuals. That would have been, I think, anomalous in terms of jurisprudential reasoning. And so it is, for me at least, unsurprising that we haven't seen this cascade of criticism of the right finding in that respect. And they were very quick to say, Article 2, of course, is going to arise where there's a real and immediate threat to life, the quintessential kind of Osmond test. But it doesn't arise here, so we don't need to deal with it. They kind of parked that. So it really, they insulated themselves in those respects. It's standing that has caused the greatest consternation. And that's because it's logically very hard to follow the court's approach to standing in Varen. As I say, you have this very clear Article 34 of the Convention. Direct victimhood is what we understand. Individual justice is one of the core principles of the European Convention on Human Rights. It's directed at ensuring that individuals who have been wronged, who have had their rights violated, have a way of finding remedy with respect to those violations, traditionally against the state or authorities of the states. As a result, actio popularis is something that is not permitted with respect to the European Convention, not before the European Court. Climate change is one of those areas that lends itself very nicely to an actio popularis, right? Because everybody's impacted by climate change. There is a very clear public interest in taking steps to ensure that authorities, that organisations, that the state more generally take steps to address the climate catastrophe. But that is not what the European Convention on Human Rights permits. So what to do? How do we then enable individuals who may not be currently immediately affected by climate change. They can't provide medical evidence to demonstrate that they are suffering physiologically as a result of climate change. They have not been displaced. They have not been exposed to forced migration issues, which we see occurring at a great rate in other jurisdictions, so that we have decisions that involve direct victims, like the Inter-American Court's advisory opinions, Daniel Billy, Human Rights Committee's decision against Australia. These are things that are happening. But here, mercifully thus far, within the north at least, northern hemisphere, we are not yet at the stage where we are able to say definitively that these are situations that people are experiencing. Caveat that, we'll talk about the Greenpeace and Norway case shortly. So how do we get around the fact that we may not have victim status now, but that in order to be effective, in order for the convention to be effective, there needs to be some mechanism of having rights enforced? Because what else is the point of a positive obligation? Are we now saying that, okay, there's no utility of having a positive obligation in this context, we'll just wait until your rights have been deleteriously affected? That seems, one, fatalistic, two, counterproductive, and three, contrary to one of the other essential principles of the convention, which is effectiveness. So we end up in this scenario where, before Veron was released, a lot of debate. Are we going to see a finding? Who has standing? Well, clearly the associations won't have standing, but the four individual complainants, they've probably got a good chance to have standing. And what happens? The inverse. The two associations are found to have standing, and the four individual complainants are found by the court not to have standing. And how we get there is by the court creating this what they posit to be a very narrow basis upon which associations in the very specific context of climate change can bring proceedings, and again, a very narrow basis upon which individuals can bring proceedings, again, specifically to climate change. And the individual complainants who were members of the association in Veron did not have standing according to the Grand Chamber because they hadn't provided sufficient evidence to demonstrate that there was this real adverse, significant and differential to them compared to other individuals in Switzerland, impact of climate change such as would warrant them having standing. In contrast, and utilising the new test that the court had developed, the association did. And this was a 16-1 decision with Judge Wright, the UK judge, dissenting, and it not because he disagreed with the catastrophic effects of climate change, but for this very point about legitimacy. He could not square how that decision fit with Article 34, the court's repeated emphasis that this is not an actio popularis, and the very clear function of the court as being a subsidiary court. Its purpose is to work as a backstop. It's not meant to be leading the charge according to court itself in terms of subsidiarity, and also according to Judge Wright. So you have this scenario in which the association has standing, but its members don't. And as Judge Wright says, how is this anything but actio popularis? You're telling me that these individuals who are members of this association don't have standing, but the association does. That is, how do we square that peg? And it's hard. And some academics say you can't, and just deal with it, because the convention has to be effective. To use the words of Bob Dylan, gather around people, wherever you roam, and admit the waters around you have grown, and accept it that soon you'll be drenched to the bone if your time to you is worth saving, and you better start swimming or you'll sink like a stone, for the times they are a-changing. Right? The waters are up, the earth is on fire, something's got to change, and if the convention wants to be effective, this is what you've got to do. There is that line of argument. There are other academics who have tried to square the peg. So George Letzis, for instance, says it's not a binary. It's not that it's actio popularis masked as something alternative, and it's not an error. What the court did was say, in the same way that it permits people to represent the interests of the deceased, you can represent the interests of future generations. And climate change is disproportionately going to be borne by future generations. And that's what associations do. And there's no reason normatively, if we can allow the court to hear complaints with respect to the deceased, while we can't allow the courts to hear complaints with respect to the unborn. Now, those of you like me who work with respect to reproductive autonomy may freeze a little bit in the context of the rights of the unborn, but that's okay. We'll park that for a moment and we'll just focus on standing. And it's not representational because these are not members of these associations. These are people, these are children unborn yet. but somebody must represent these interests because it is an intergenerational issue. Thus, we have standing for associations who are lawfully formed in the jurisdiction in which we're concerned, who are specifically and directed at dealing with climate change and the implications thereof. So we're not talking about, as the Wolfson report refers to, the Public Law Project and general public interest groups. We're talking about specific organisations that are directed at addressing climate change, and who, as a consequence, are specifically placed in order to be able to bring these proceedings. It looks a lot like Fleet Street. For those of us who work in public law in the UK, it looks a lot like what we understand to be public interest standing in this jurisdiction. Now, to circle back, so listen, I can't give you an answer here as to whether or not that was a legitimate fandangling, whether or not you can square that circle. I don't know. Listen, we could go around in circles with respect to it. The reality is it's happened. But what the court has done itself is address exactly what Darren was saying about the narrative. Because in the cases that have come after it, they have narrowed it very heavily. They have sought to be very clear with respect to how these tests apply and the situations in which they apply, to the extent that there has been very little success post-Veron with respect to climate litigation. So there was at least 3 applications declared inadmissible with respect to standing of individuals because of the threshold that they developed in Veron. And then you get Greenpeace, which was a case again in which you have individuals who don't make out standing, despite the fact that some of these individuals are Sami. And one would think perhaps that the cultural implications of climate change for the Sami population may well invoke the court to look at Article 8 and the scope of then the right to private life and family life and the cultural protections inherent within there. But no, the court took again a very, very narrow focus with respect to standing on with individuals. It recognised that Greenpeace had standing as an association, made very little reference to future generations as part of that, but then also found that Norway had complied with its obligations. So it took, again, a very narrow approach to its and emphasised its subsidiary function. And I think what you can see here is the court doing that function, which is we acknowledge our legitimacy is perilous. We appreciate that we are at a state here with a topic that is incredibly political, and we need to be cautious in how we go forward. It's a nearly 102-page judgment in which they go through in minute detail the process of decision-making in Norway before reaching the conclusion that it complied with the procedural obligation. And it is just the quintessence of a subsidiary, the principle of subsidiarity. You then have another decision, kind of LCIL, and I apologise because I will have butchered that pronunciation, which is an environmental harms case. And that was a case that involved long-term dumping of hazardous waste by criminal organisations known by the state, Italy, with very little done about it, leading to cancer, all forms of right to life issues. And here we have another attempt by an association to claim standing. And the court says here, no, Veron doesn't apply. This is environmental harm, not climate change. Now, there's dissents in that judgment. Unsurprisingly, Judge Sergetis, as I said, he is the father of effectiveness. And I don't think unfairly questions how you draw that line. How does one draw a line between environmental harm and climate change? But the court has done that. And so in terms of how the court can protect itself against this existential threat, not climate change, it's tried to do that by giving standing to associations. It said, no, you go forth and deal with it. But in terms of the wider threat to its legitimacy as a result of its jurisprudential approaches, it does that, and this is not the only area in which it's done it, by then very narrowly interpreting the advances that it makes. So, Judge Ike says as a court, we typically take a very cautious approach, and that is true. The court does that. It does, much to the chagrin of those of us that work in the field who would wish it does things more rapidly at times. It does do them very slowly and very cautiously. There will inevitably be moments like this where you can't just take a small step. Someone's going to have to jump. There is no step in between. There was no middle step for standing here that the court could use. It had to do what it did. It jumped. But having done that now, it's staying very carefully still in its space, and it's very cautiously progressing. And it's leaving states to do the legwork, and it is reasserting the margin, and it is asserting subsidiarity and deference. And I think that, in a way, is how it protects itself from this existential threat. It's not something that can be done to it. PACE has, I think, given up an attempt to amend the convention. And like I say, I don't think that actually the issue is with the right as formulated. Most countries don't take umbrage with the fact that there is a right to a healthy and clean environment in other international treaties, or that Article 8 requires that states take proactive steps. They take umbrage with being, well, the perception that this supranational court is dictating to them that they have to take explicit steps, that if we use the Wolfson report as the nomenclature, that it is impacting the prosperity of the country. But as I say, I think, in terms of the way in which climate change can illuminate the court's protective functions, its jurisprudential restraint is what it's doing. Now, that in and of itself raises legitimacy concerns, because it is not uncommon for dissent within the court to then be raised about the court not following logically the law to its extension because of concerns about state perceptions. But that is for another day. That's another existential crisis, and we can only put one fire out at a time. So yes, just to sum up, climate change, I think, is one of those areas that, as the Wolfson report shows, can be tacked on as almost an addendum. And it's then easy for us to overlook it because we think it's not really a problem. It's not something that we should be concerned by. But actually, it's the very fact that it can be added on without people batting an eyelid, I think, that should give us pause. We should be very careful to scrutinise the decision, to contextualise it not just within the wider international jurisprudence, but also within that which has come after it, so that we can do what Darren has, I think, very, very sensibly encouraged us to do, which is to reform the narrative. To the extent that Verum was a massive leap and was judicial activism, maybe, may not, but what we can see in the jurisprudence coming after it is that Strasbourg restraint that we know and apparently love so well. And so, yeah, it's no big deal, as the youth like to say. NBD, calm down, it's all good. Thank you, everybody.
Yeah, thanks very much, Stevie. So now we open it up to questions.